So, shall we start?
Now, shall I start
Oh,
now?
okay, sir. Good afternoon, everyone. Welcome you all to the workshop of the ICSI IIP on the disciplinary case against IPS. Today, we have with us Mr. Siva and Prasad Puvvala as a faculty and taking the second session on the topic of disciplinary case against IPS. Sir, you may start now the session.
Okay. So, good afternoon to all professionals, sirs and madam. Yesterday, I have discussed some case studies, and today also I will continue the same, particularly CARP and liquidation. What are the disciplinary actions that are initiated by the Disciplinary Committee of Insolvency and Bankruptcy Board of India? If you take the disciplinary cases, per annum, it is around 24. Per month, it is almost 2. 2 means it is a high side. And every month, two people, they are punishable under various lapses or errors. And thereby, the profession code they are not following. They are not following, they are taking the profession in a casual manner. Only few people, that too, that 24 per annum. And here, my observation is this is a simple issue. That code is also a simple 256 sections, and the decided cases are available. That is, judicial pronouncements are available, and the rules and the regulations that is updated by IBBI from time to time. Not only that one, the continuous education program also conducting by the IPS. And here, in my personal opinion, this is not a rocket science. It is a simple science. Whatever the cases we have discussed yesterday and today also, the lapses are negligence on the part of the some of the IPs. Advertisement, even though they told clearly within 3 days means why they are giving a late. And COC formation, if at all they told the clear cut guidelines are given in the regulation, why they are taking a lot of time. And even though they told that a related party is not part of the COC means why they are allowing. Even though the IP is the CEO of the company and the erstwhile directors, there is no powers. Still, why they are handling the bank accounts, I could not understand. And even though, particularly while selling the properties, the reserve price also drastically they are reducing, even though the guidelines are there in the regulations, liquidation regulations, all are clear cut. It is as good as 2 plus 2 is equal to 4 type of mathematical formula. The clear cut and the clarity guidelines are there. There is no ambiguity. But still they are not following means that is the lapses are on the part of the IP, not on the part of the system. So even though it is a good profession across the world, lot of people they respected the insolvency profession, but in the initial stages, if this is continued, then it is a great image risk to the professionals. But what I told is code is 256 sections. Regulations, updated regulations are available in the IBBI website. Whatever the CIRP, whatever the liquidation, whatever the voluntary liquidation, whatever the personal guarantor to corporate debtor or the pre-packed insolvency, all are updated versions are available. We need not refer, we need not contact any person. And simple and lucid language. It is very easy to understand. But still, Some of the people, they are taking the profession in a casual manner that should not arise. This is my personal opinion only. So, once it is clarity is there, no scope for misunderstanding, no ambiguity in the guidelines, but still people are bypass that guidelines, bypass the regulation, bypass the code, thereby it affects their profession. And some of the people, without the particular verification of claims, they are admitting the claims. Once the claim is received on day-to-day basis, you have to open the cover or you have to open the electronic form and verify how much you claim, whether it is reflected in the books or not. What is if at all any agreement is there for interest clause, or if at all any foreign currency loans are there converted into Indian rupees as per the official rate given by the Reserve Bank of India on the insolvency commencement date. All are clear cut, clarity is there. And even examination, LIE examination, all are covered. Once that examination completed, it is difficult to pass the examination after thorough reading of all the rules and regulation and code and the judicial pronouncement. The professionals are completed that examination. Still, some people, few people, they are violating the norms. So that's why the IPA, ISC, IPA also, this type of classes are required. A legal and political system, any legal and political system theoretically functions on a sound principles, checks and balances are required. Everywhere checks and balances are required. Otherwise, the system will not work properly. As postulated by French philosopher Judge Baron de Montesquieu, as further adopted in the Indian Constitution and polity. So, checks and balances are there. Then only the system will work. Suppose the code is given and the regulations are given, rules are defined, and the judicial pronouncement already there, and we have to follow that one. There is no personal agenda. There is no your personal decision making. All are laid down instructions only. Under the new insolvency regime, on the initiation of the corporate insolvency resolution process, the powers of management or board of the corporate are suspended and gets vested with the interim resolution profession. That too, it is appointed either by NCLT or by the financial creditor. And to manage the operations of the assets of the corporate debtor. Okay, here all IPs, they should have the knowledge about how to run the company. What type of skills that are required? Okay, we are experts in legal. We know pretty well about the particular IBC code or regulation. Still, how to manage the organization, how to manage the men that are working in the organization, what are the various functions, whether it is a production department or marketing department or personal department or the finance department, etc., etc. The managing men is also an art as well as science. So they have given a good position to the IP. So that too, the adjudicating authority approved your designation and they have given that assignment to you. Because if at all A to Z, if at all the adjudicating authority oversee the operation, judicial time is also wasted. So that's why one competent person is given that a task means we have to maintain the standards. That is the problem. Some of the people, they are not adopting the standards. That's why the problems are arise. IRP or RP play a vital role, efficient operation. The preamble of the code also they clearly told and categorically told the efficiency at all the sub process of a CARP process or liquidation regulates, manages, administers the entire the insolvency and bankruptcy as a agent to the adjudicator. You are the court appointed person. You are the agent of the adjudicator. If at all are overseen by the adjudicator, where is the time for judicial time for the adjudicator? They have appointed as a competent person. That too, you know the A to Z of the code. You know the A to Z of the regulation. That's why you have caused that limited insolvency examination. As per the Vishwanathan report on insolvency 2015, this creates a positive externality and better utilization of judicial time. Once they have identified one person means it reduces the judicial time. That is either NCLT or NCLAT or Honorable Supreme Court of India. These are the adjudicating authorities. The worse performance of RP, the more adjudicating authority may need personal support. If at all the RP is not handling the case properly, then automatically lot of time to be invested by the adjudicating authority, which is not correct, which in turn causes the inordinate delay. I have identified the judicial authority identified one person, competent person to oversee the affairs of the corporate debtor means we have to rise to that occasion. We have to rise to that occasion. Efficient regulation of RP in turn ensures maximum assets and less adverse impact. Once I followed the total, the code, the regulation, the rules, the whatever judicial pronouncements are there, then the efficiency will increase. Whatever the disciplinary committee initiated, particularly these actions, all are related to small areas. It is not a technical subject. It is no technical jargons are there in the code or regulations. Easy to understand. That to matured persons, that to 10 years experience of professional qualification or 15 years of experience in managerial capacity. We are matured persons. We have to adhere the code. We have to adhere the regulation. Such authority is an important function or RP cannot be left unregulated. Today, on account of a disciplinary action that is initiated by the disciplinary committee on an average per 2, that is not acceptable. That is not acceptable. Endeavor is to look out the discretion given the disciplinary committee. The disciplinary committee is having full powers. Even though investigating authority is there, the investigating authority, whenever he asks some information, whether you are doing correct or wrong, immediately you have to provide that information. Some of the RPs, those who are facing the problem of the disciplinary actions, they are giving wrong information. Okay, once wrong information, the disciplinary committee, investigating authority, they will come to your office and they will verify the files. If at all is wrong, then the penalty will be more when compared to the earlier one. Endeavor is took to discretion given the disciplinary committee, who under the code and how it has been exercised, help us understand whether the checks have been proportionately laid down and practiced. Whatever the checks, whether in the practice that is imbibed or implemented or not, that is they will verify. If not implemented, then they will take into task, particularly whatever the punishments are there, they will definitely impose the punishment. The rule is for all is they are all people, the same rule is applicable. There is no favoritism. As per section 220 subclauses 2 to 6, the disciplinary committee on being satisfied that a sufficient cause exists may impose penalty. Okay, this is a wrongdoing. Definitely they will impose the penalty. Or suspect or cancel the registration of the insolvency profession. Today that is happening. Yesterday, whatever the 20 cases I have discussed, in the 20 cases, it is clearly visible that IP is doing wrong things. Once the COC has to approve the his honorarium or fees. If at all he is having the check power or drawing power of the account, he should not touch for his honorarium. Once it is approved by the appropriate authority, that is none other than the committee of creditors, then only he has to withdraw. And the insolvency resolution process cost. Some of the people, they are spending lavishly, which is not correct. Because it is a sick company. The two liquidation, the liquidity problem is there, and still they have to pay some the operational creditor or financial creditor, or including operational creditor, workers' salaries, and all are there. If at all I am spending lavishly, where is the funds available to distribute it to the stakeholders in the waterfall mechanism? So that's why we should be more cautious. So that is my company, not our company or your company. That is my company. As long as 180 days or 270 or 330 days, I am staying in that company as a CEO, Chief Executive Officer, I should take care of. I should not give any scope to the others to pinpoint any mistakes, because it is a simple code, not a complicated code, and this is only 256 sections, and regulations are very easy, rules are very easy, and judicial pronouncement already available. It is available in the web also. The penalty prescribed 3 times of the amount of loss caused or likely to have been caused to the persons concerned on account of such contravention. Whatever the loss is incurred, 3 times. 3 times is that is a minimum the penalty that is going to be imposed. If a loss is 1 lakh, the penalty is 3 lakhs. Such a or 3 times of the amount of unlawful gain made on account of such contract. If at all any unlawful gain is there, 3 times of the unlawful gain, that is the penalty. So the penalty is also clearly defined. Okay. In that case, in case where the amount is unquantifiable, sometimes it is unquantifiable, not quantifiable. The upper limit is 1 crore has been fixed as an imposition of penalty. That type of a stringent guidelines are there in IBC. Before accepting the particular assignment, first we have to see what is the code. Once I got thorough with the code, then automatically my profession will run in a smooth manner and efficient manner. Additionally, IBBI direct any person who has been unlawful gain or averted loss by indulging any activity in contravention of the code, given amount equivalent to such unlawful gain or aversion of the particular loss. That amount not belongs to me. That belongs to the stakeholders. Because you are the administrator, you are the coordinator, you are the facilitator between the court as well as the committee of creditors. You are not having any judicial power. You are not having any delegation of power. You are the court appointed person, official. That too, based on the decisions taken at a committee of creditor, we have to implement strictly. But at the same time, managing the show, the managing the show of the company in an effective and efficient manner.
डेट्स वगैरह सब लिखी हुई है
Further, the provision for
36 लाख में बैठा है ना तो मजा है
further, there are, sir, further, there are provisions restitution such loss to a person who suffered the loss and it is identifiable.
સામે ગ્રાઉન્ડ ફ્લોર પર ઓપ્શન છે એમાં રેસિડેન્શિયલ
Further, there are provisions to restitution of such loss to a person who suffered the loss identifiable. So these are the various the factors, the various guidelines that are there to run the CIRP or liquidation in an efficient and effective manner. Not only this one. Now, I will discuss one by one. What are the findings of the IBBA, followed by one case study. From time to time, the IBBA is also doing some research in this area. And what are the findings? They are advised to the members by way of circulars also. We have to go through the circulars from time to time. Beyond all these things, the quarterly information journal, that is quarterly journal of IBBA, it is a valuable information is available in the quarterly journal that is issued by the IBBA. So that's why we will discuss about what are the findings of the IBBA with regard to the profession and what are the case studies, all these things. Today we will discuss.
वैल्यू रेसिडेंस क्या करें ज्यादा है तो ये सब ऑफिस वालों को रेसिडेंस में कन्वर्ट कर देना चाहिए वैल्यू बढ़ जाएगी बैठे बैठे तो बढ़िया और वैल्यू बढ़ जाएगी
Okay, now I will discuss about the IBBA observations and followed by the disciplinary action, whatever the cases are there, that is initiated by the.
ये मारा मगजमारी ने पार्किंग आते બધું
Please unmute your. Now, the first one is payment to creditors during CIRP. This is one of the observations made by IBBA. They have issued circular in this regard also. What is that payment to creditors during? The court requires every creditor to submit a claim as on insolvency commencement date to the IRP. Section 14 of the code prohibits settlement any such claim during CIRP requires resolution plan to deal with them together with the manner decided by the COs. So whatever the before insolvency commencement date, whatever the dues are there, that should not be paid. During the course of a CIRP, whatever it is there, it is subjected to approval of the COC. Under section 30, subsection 2. Section 53 of the code provides waterfall mechanism for a distribution of a liquidation process. CIRP its liquidation. This is a clear-cut instructions are there. But some of the people, even though these instructions are there, still before insolvency commencement date, if at all their company is due for the operational creditor, they are paying, which is highly irregular. Highly irregular. So therefore, the RP cannot clear the dues and any creditor during the CIRP, as this amounts gives preferential treatment Once you are paying during the CARP process, it is treated as a preferential treatment to one creditor over the others, thereby alters the priority mandate given in the code. That's why this is very, very important. We should not pay whatever the dues are there of the corporate debtor before insolvency commencement date. He cannot also allow any creditor who is having custody of funds of the CD to appropriate towards his own use. Suppose any amount is there with the creditors, he should not appropriate, he should not set off that one. And the IP should take care of all these things. That's why IP has to go through the financial statement or books of registers, and they have to find out how many data are there, how many creditors are there, how many prepaid expenses are there, how many advances are made by the company. All are to be understood by the insolvency profession. This is not only impacts the interest remaining creditor, but also may seen as a compromising independence and the integrity of the IP. So this is an observation of the IBBA. Now we will discuss one case study. Only 1 minute, sir. Only 1 minute. Names of the name of the corporator. That is the action initiated by the disciplinary committee in one case. The corporate debtor name is King's Electronics Private Limited. This is a CARP, Corporate Insolvency Resolution Process. The dated is 11th August 2023. In that case, what wrongdoings done by the IP and what punishments are awarded by the disciplinary committee we will discuss. Irregularity in voting process of IP has contravened the provisions of the code and regulation, not counting the votes of 2 major COC members. What is the problem? Once a clear-cut guidelines are there, you have invited the claims. Claims are also submitted, claims are also verified, and you have to segregate the claims. Who is an operational creditor, who is a financial creditor, who is a class of creditor, under the financial creditor, who is a secured and unsecured. The Union Bank of India Bajaj FinServ Limited having 8.1 and 14.7 voting share respectively for a replacement of her as IP. And these 2 members, they have not, the resolution professional not taken into consideration. As I said, agenda could not be passed. And if vote either both of the COC member UBI and Bajaj FinServ Limited been counted, Mrs. Poonam Basak IP would have been replaced. That's why she has not taken into account of these 2, which is highly irregular. Okay, if this is not the company, we will go to another company. Thereby, what will happen? Image risk and punishment. The erroneous voting benefited and served the personal interest, which furthered COC members approached the adjudicating. Unnecessarily, the issue is percolated or in the hands of the adjudicating authority to decide for replacement of RP and the extension of CARP period. On account of this problem, 2 problems are arising. One is the image risk of the IP, and the second one is delay in the process of CARP. So, if at all we are hiding, all are transparent, all are recorded, and the financial creditors, they don't sleep, they will raise the particular issue to the adjudicating authority. Whether it is a financial creditor, they don't sleep, they don't, they will definitely raise this issue. Seeking appointment as a liquidator by passing a COCIP on completion of 270 without consulting COC. We are facilitators. We are administrators. We don't have the power. All our powers are vested with the committee of creditors. So the COC bypassing the COC's this one liquidation, consulting COC file as a the liquidation application where she prayed to adjudicate to confirm the appointment as a liquidator. Despite knowing that application filed COC for extension CIRP was pending. One side pending application filed in adjudicating authority. Second side that resolution the IP also filed the liquidation and she asked confirm the liquidate as a liquidator. Only in one court the two applications are there. How the adjudicating authority will view this about the IP. Consequently, adjudicating authority allowed the application to replace the Mrs. Poonam Basak as a RP and appointed new RP and CIRP extended by adjudicating authority. Adjudicating authority rejected the application filed by the IP for liquidation. So if these type of incidents are there, then automatically the image risk will increase. That too in the public. These names are also displayed in the web also. Because this is not a confidential information. Whatever the disciplinary committee taken action against the IP, all are reflected in the web also. And these are available in the IBPA also. And whenever the financial creditor are reviewing or renewing the empanelment, they will take all these things into consideration. Or some IPs, if they allotted case and they are having some disciplinary cases, other IPs, they will raise their tone and inform to the financial creditor. So that's why this type of incidents should not occur. What penalty imposed by the disciplinary committee? Suspension of registration for a period of 3 years. Once 3 years gap is there, then automatically knowledge updation is a big problem. The whatever the remuneration she is getting, that is also a big problem. Beyond all these things, image risk is another big problem. Learning lessons. What are the learning lessons? Inordinate delay in CIRP process destroy the value of assets. Once the CIRP process is delayed, whatever the assets are there, that is rusted, the value will deplete over a period of time. If a building, if at all it is taken to the occupation immediately, then the damage will reduce. The value may increase. Once after 2 years or 3 years, if at all the building, the production department premises is rusted and some other machinery may not work out. The value, destroy the value of the asset. At whose fault? That IP fault. And make the performing assets as a non-performing. Failure to act as an object and mandate the code, that is a resolution of the COC and a decision-making body. So, to go for liquidation or to change the RP to the IRP to RP or RP to liquidator, that authority given to COC. We should not take that power into our hands. Next, this is a feedback or opinion of the IBBA. Window for view. This is a feedback. IBBA has issued one circular. Window for view. What is a window for view? Regulation 16A to 9 of CIRP. Authorized representative shall circulate agenda to the creditor in class and seek their preliminary views on any item agenda enable them effective participate in the meeting. He is a coordinator. He is a coordinator between the IP and the class of creators. And the creators have time window at least 12 hours. For voting minimum 12 hours, the window to be open for their preliminary views, and the said window must open at least 24 hours after the authorized representative sought preliminary views. This is mandated, that too it is defined under regulation. And further, regulation 25(6) of the CARP regulation requires authorized representative to circulate the minutes of the meeting to the creators in the class, announce a voting window at least 24 hours before the window opens for opening of instructions, and at least 12 hours. In this case, not related to this one, another case that is decided by the disciplinary committee in one issue, that is with regard to IVRCL Limited liquidation. That is 2nd August 2023. What has happened? What are the wrongdoings of the IP in the IVRCL Limited? Contraventions. These are the contraventions, findings. Prescribing non-refundable participation fees. Prescribed. Only 1 minute, sir. Only 1 minute, sir. Sorry for the inconvenience. Sorry for the inconvenience, sir. Prescribing a non-refundable participation fees. IP in the first 2 e-auction process called non-refundable participation fees of 25 lakhs for the bidder to participate in the bidding process. There is no such guidelines in this regard. But a non-refundable participation fees on his own he has implemented. However, he removed this condition for the pre-bid participation fees by publishing an addendum to the main advertisement. The non-refundable process participation fees was again prescribed for participation in the second e-auction, whereout 23 prospective bidders, only 3 are deposited the fee. Once 3 are there, how he will get a maximization of the bidding amount? Indicates that the submission of the said amount acted as a deterrent to the prospective bidders. And the conduct of IP in the auctioning of the assets of the CD is inconsistent, unfair, and not acceptable. Delayed valuation during the liquidation process. These are the findings of the disciplinary committee with regard to IVRCL, the liquidator. IP has appointed valuer for valuation after more than 2 years of the liquidation commencement date. Even though there is a guidelines, there is a time schedule for determining the reserve price for third e-auction process on the advisory of the committee, stakeholders consultative committee. The reserve price of third auction was reduced by 25%, where it has been reduced by 10%, which has led significant financial implication. Once it is not sold, abruptly we should not decrease the amount. But in this case, reduce that amount, definitely the prospective bidders, they will purchase. It is a duty of the IP to guide the stakeholders consultative committee pertaining such actions. The fees BOD restructuring advisory LLP. The company he has given restructuring amount also paid through company's account. That is not part of the insolvency resolution process cost. The BDO is one consultancy company. They are doing the restructuring work. That is the corporate data or lookout, not the IP the area. The fees IPA has initially 8 months, 55 lakhs per month, which was subsequently reduced to 27.50 from 9th month, and it was further reduced 15 lakhs onwards. Why it is reduced? But at the time of agreement, once you are going to pay and you are going to utilize the services of IPA, fees is determined. But after certain months, why you are reducing? Is there any papers available? No papers. Abruptly he reduced. Why he is paid higher amount? Why he is reduced? It is a question mark. There is no document on records detail the objective criteria adopted to reduce the price. In the fixation of fees to IP and also fixed amount not reasonable. Reasonable amount. Whenever we are taking the services of IP, reasonable amount to be paid. Otherwise, if at all exorbitant amounts are paid, then the stakeholders will get a lower amount. Penalty. On account of this one, suspension of the registration of IP for 1 year. Suspension of registration of IP for 1 year. What is the learning lessons? Inconsistency in conducting auctions during the liquidation period, lack of objectivity, transparency, justification, reasonableness in fixation of fees to the IP. Why has a fixed higher amount? After certain months, why reduce? Again, why has reduced? And if at all any document is there, why he is reducing the fees? No papers are available. So that's why definitely this type of incidents are there. The disciplinary committee take a view how much penalty or what type of the penalty or other things they will take into consideration all these factors, and accordingly they will define. Now, this is the findings of IBBA. The 16th findings, circulation of minutes. Once the meeting is over, this is not a big meeting, and even today nobody is writing on the paper. Everybody is writing on the particularly this one, and so many people are having digital signatures are also. Okay, this type of minutes only 1 page or 2 page, get it signed by the members who attended the CARP meeting, COC meeting, and immediately circulated the same to the other members, all members. So circulation of minutes. COC is the authority to decide various matters in a CARP, including approval or rejection of a resolution plan. It takes a decision through its meeting, and the decisions are reflected in the minutes of its meetings. The CARP regulation therefore requires RP to circulate the minutes of the meeting by electronic means to the members of COC and authorized representative within 48 hours. What is happening? In some cases, 2 months or 3 months delay is there. For the sake of small result minutes, whatever the minutes are there and signed by the people, it is very easy to communicate the same, if possible, immediately. But here, in some cases, in the coming cases, after 6 months, which is a highly irregular. Conclusion of the meeting. Okay. Now, one more, the disciplinary action initiated by the disciplinary committee. That is the 24th. What is this company? JSM Devacons Private Limited. It is a CARP case, and the decision is given by the disciplinary committee on 20th July 2023. What is the decision? What is the contraventions? What are the wrongdoings that are committed by the IP or liquidator or IRP? Charging fees, verification of claims. It is part of your duty. Whatever 3 lakhs or 2 lakhs or 1 lakh or 50,000 or 75,000, whatever it is given. In that only, whenever you are receiving claims, it is your duty to verify the same. You should not charge extra amount for verification of claims. A sum of 1,24,500 for verification of claim at the rate of 500 per claim for 249 claims was the charge. And another lot, 1,87,000 for verification of claim, for claim 500, 374 claims charged as a part of CIRP. It is not a part of CIRP. It is a part of your duty to verify the claims. Because you are a full-time director, that is a CEO of the company. For that, if at all their remuneration is given less, you object it, then only these things are happening. Delay in filing the report of certifying constitution of COC. And there was a delay of 10 days in filing the report of certifying the constitution of COC before the adjudicating authority. However, submissions made were justifiable as a delay was not intentionally because the IP wanted to get the documents. And a clarification for maximum number of home buyers so that they may be included in the COC. Okay. If at all genuine reason is there, nobody will object. If at all number of home buyers are there and a delay was happened, no problem. The delay condoned first COC meeting. There was a delay of 8 days in the conducting of a first COC meeting. What penalty imposed? Directed IP to deposit amount of 1,87,000 in the account of a CD, JSM, Devacons Private Limited. If the sum is already from the within 45 days of the issuance of the said order. Once I have taken some extra amount that is to be deposited, and the penalty is also 3 times, but in this case, luckily, only the whatever the amount he recovered and he got that the disciplinary committee is kind enough restricted that penalty to that amount only. Learning lessons. IP has wrongly presented to the COC an additional expense for verification of claims, which is an inherent duty of the IRP. It is a part of your duty. For what purpose the monthly amount? Inclusive of all. If at all any IP services are there, at the time of your acceptance or after that one, you present your whatever the views are there to the COC and get it approved. But this is an irregular amount. Inclusion of cost in CIRP, IRPC, insolvency resolution process cost. This is the findings of the IBBI. This is the findings. 17th finding, they have issued circular in this regard. Section 5, subsection 13 of the code, read with regulation 31 of the CIRP regulation specifies what is included in IRPC, insolvency resolution clause. Beyond that, we should not It includes only those costs which are necessary for CAR. It includes only those costs which are necessary for CAR, not all costs. The law does not allow inclusion of any other cost in IRPC. A member of a COC may incur cost to travel to attend the meeting of the COC, and the COC may incur cost obtaining legal advice or engaging professional, or the CD may have the incurred cost before insolvency commencement date. The RP may pay penalty for non-compliance with any law during the CAR. These are the instances where such costs were included in the IRPs. So here, whatever the irregular costs are there, it is not to be debited to the account. Before insolvency commencement date, whatever the costs are there, that is not to be paid. And the member of COC, suppose the financial creditor, whenever he is deputing his officer to the COC meeting, that is not to be debited to the IRPC cost. These costs are also allowed by the IP, and which is an irregular one. That is the findings of the Insolvency and Bankruptcy Board of India. In another case, the case number 35, the name of the corporate debtor is Hirakud Industrial Works Limited. It is a CARP. The dated is 13th July 2023. And in this case, what are the observations of the disciplinary committee, or what are the contraventions of the disciplinary committee? Constitution of COC without verification of claims, which is highly irregular. Financial creditors were admitted into COC based on the confirmation debt letter of a CD and not based on the verification. In that case, if at all you are allowed or listened the CD's version, it is not a professional ethics. You are an independent one. Whatever the claims are there, whether the claims are genuine, reasonable, and as per the book of accounts available. If not available, you ask the claimant to produce the evidence, and after verification thoroughly to be admitted, and this is to be advised to the adjudicating authority also. Based on corporate debtor's debt letter, simply acceptance whether it is reflected in the book of accounts or not. The constitution of COC without verification of claims, the financial creditors were admitted into the COC based on the confirmation of the debt letter of a corporate debtor and not based on the verification of book of account of a CD. IP has failed to verify the claims of the creditors without corroborating the documents. He is not correlated with the documents. He is not comparing with the document whether the claim is whether the company has taken any loan or any supply of raw material or supply of services is there or not, simply verified under constitution of COC. Thereafter, whatever the decisions taken by that particular COC is null and void. Okay, delayed claims, if at all claims are delayed, that is a different issue. It is an irregular COC committee. Non-compliance of adjudicating authority order for submission of proof of claims. COC member, adjudicating authority passed the order dated directing the IP to produce a sufficient proof of debts, but this order is not compiled. Once you are not carrying the orders of the adjudicating authority, you are disobeying the orders of the adjudicating authority. Non-compliance, it is a serious nature. Sometimes the adjudicating authority may give a punishment also. The adjudicating authority again validated, noted the previous order not been complied, gave a last chance to comply. Why we are reminders on that particular order? And sometimes in the presence of the all the IPs in the court, if at all something they talk, particularly the adjudicating authority, on account of this wrongdoings, then it is a image risk. And the second order also, once you have admitted, under what basis you have admitted? That is the simple question the adjudicating authority asks. You have to submit the proof. Sir, this is on the basis of the corporate data letter. Whether it is correct or not, they will approve. And if not approve, remove that person. But once you are disobey the orders, it is a serious one. However, it has been observed that Honorable NCLAT order dated that IP filed that is a number so for modification of the order dated rather than complying with the same, which is not correct. We should not fight with the adjudicating authority. The problem lies with us only. The error lies with us only. Hence, IP did not comply the order of adjudicating authority till so-and-so date for 9 months. And thereafter made an attempt to modify the order dated so-and-so that requires to submit the proof of the final including COC and did not readily submitted the required details to the adjudicating authority. Simply corporate data or letter you have admitted. That data is reflected in the books or not, you have not verified. And thereafter you came to know that this is a wrong claim. And on that wrong claim, the adjudicating authority raised objection. What is the proof to admit this one or evidence? What is the paper or books of registers, etc., etc.? You have not informed to the adjudicating, and they have issued a second reminder also. All these things irregular practice. Inclusion of related party, the same RP, CD into COC. Committee of creditors is a non-related parties, not related parties. There is a connection between the CD, Nandakini, the applicant of a financial creditor, member of COC, and which deposits. And various members of COC related party of CD and have been unduly assigned voting rights. This COC formation is also not correct. Unrelated party, instead of unrelated party, all are related parties only. Once a related party, definitely their decisions are in a different manner. So in this case, definitely the disciplinary committee take a view and they will give some penalty. The successful resolution applicant is also ineligible as per section 29A. Whatever the conditions that are mentioned, these people are not eligible means if at all you are taking that people as a prospective resolution applicant, which is a highly irregular. Submit the resolution plan being related party of the CD by having common director. And signing affidavit under section 29A on behalf of the resolution applicant IP had affixed the signature on the affidavit under section 30 subsection 1 with section 29A, which is required to submit authorized representative of the resolution applicant. Despite that a particular resolution applicant, successful resolution applicant, being a related party and ineligible under section 29A of the court, IP submitted a complaint certificate in their favor, finding them eligible for submission, which is a gross negligence. once it is a related party, and you are also certifying the compliance certificate, then it is a highly irregular practice, which is not acceptable as per the professional code. So that's why failure to obtain the claims from workers of the CD. So he really knows about the workers are also having the claims. He is failure to obtain the claim from the workers. In the same case, being aware of the substantial claim of workers of the CD and ongoing proceedings before High Court, failed to consider the same, and he also did not advise the workers CD to file claim with him. Being you are the facilitator or administrator of the company, that too the workers are filing the claim with an high court, and you know pretty well that these are the many people the company has to pay so much amount. Still aware of this one, why you have not included in the list of claims? And especially the statutory claims including previous gratuity for the workers of the CD were not sought. No provision was made for the same in the resolution plan. Whatever the statutory dues, whether it is a gratuity or pension fund, whatever it is there, that is to be included. That is a top priority. Even in the waterfall mechanism also, that is a top priority. 24 months workers and 12 months employees. All these things are to be included. But this is not included by the IP. To conduct IP approved modified subsequently lead crashing the resolution plan by the Honorable NCLT as interest of all stakeholders were not agreed. Why you are unnecessarily inviting the higher authorities to crash that resolution plan? This is a gross misconduct of the IP. Gross misconduct of the IP. Even though he knows pretty well that the workers are having dues, it is not included. And thereby the NCLAT, they crashing the resolution plan. Penalty. Completely he is not fit for the resolution profession. Registration of IP stands cancelled. That's all. No question of 1 year or 2 years or 1 month or 6 months like that, or some penalty or some warning. No question. This is a not acceptable. Related parties are in COC. Without a verification of the financial data, you are making the member as a COC based on the corporate debtors letter. And even though the adjudicating authority asked 2 times about the production of the evidence, you have not submitted, then this person is not suitable for the profession. That's why completely they have registration of IP stands cancelled. What are the learning lessons? IP facilitated erstwhile management. We should not. For CARP meetings, you have to invite whatever there, the discussion points are there. If at all it is valid, it taken into account. But if at all you are colluded with the erstwhile management, it is not correct. Directors of the CD in extinguishment of past liabilities and prosecution from the criminal offence, thus conducting the resolution process of the CD in gross violation his fiduciary duties entrusted upon him under the code. This is the wordings of the disciplinary committee of the IBBI. IP had shown casual and a lackadaisical approach with regard to workmen dues. Once the workman is there and they are demanding, and he is not asking you to submit the claims, And even though Pretty knows that workmen are approached the High Court for their dues, and the Provident Fund, whatever the statutory dues, also not included in the resolution. This type of gross negligence, the disciplinary committee don't tolerate and completely cancelled his registration. Next, 18th findings of the IBPI. Compliance with applicable laws. Even though you are in CIRP process, it doesn't mean that suppose renewal of the listing agreement with SEBI or with stock exchanges. You have to do pollution control board for running the company. You have to do, or whatever the insurance policies that are required to safeguard the assets of the company, we have to do. Whatever the applicable laws are there, we have to follow during the CIRP process. No, I am in CIR process. It is the cool period, calm period. I don't talk to anybody. That is not correct, because the company is in a running condition. That is a going concern concept. Section 17, subsection 2, clause E of the code mandates IRP or RP to comply with the requirement under any law of the time being in force on behalf of the city. We have to comply. There is no other alternative. Non-compliance has a cost to the CD and its stakeholders, and attracts a penalty consequences. For example, listed company, several continuing obligation under securities law. Failure to discharge the obligation compromises interest investors in securities. This amounts to contravention not only the security law but also provisions of the code. The IRP or RP is responsible for non-compliance of the provisions of the applicable law if it is on account of his conduct. It is treated as a non-compliance. In this, okay, this is earlier one is observation. Now one more case, that is a disciplinary committee case. This is a 26th case. What are the observations? Uniworld Sugars Private Limited. It is a CARP case. This is the 6th of July 2023. And in this case, what are the allegations against the IRP or liquidator by the disciplinary committee? Or this is called contraventions. Failure to conduct required due diligence of the resolution plan. Once a resolution plan is submitted by the prospective resolution applicant, you have to verify whether capability, whether the creditworthiness, whether he is a defaulter with any bank, whether any criminal charges against him or not, all these things. And there was a third valuation conducted behest of the Siva. And however, third valuation does not seem to have affected the distribution under the resolution plan. If need is there, third valuation. If a wide difference is there, third valuation. For the sake of giving a known person, particularly the valuer, this is not correct. Guidelines are clear. Guidelines are for every asset, particularly whether it is a security valuation or land and building or plant and machinery, two valuation compulsory. Third valuation arises when there is a wide difference between the two valuations. Siva's name of the commercial wisdom exceeded its mandate. However, supporting logic being during pandemic, value of assets in general registered drastic fall. COC in many cases in jail to get a latest valuation of the CD, insisted the third valuation to be done during the extraordinary times of the COC, the COVID-19. As mentioned, Honorable NCLT, such precautionary exercise is violative of the regulation 24, 27 and 35 of the CAR. However, the role of the RP pursuing the third value is not established beyond doubt. Penalty. The show cause notice was disposed of. And learning lesson. IP should be more careful representing the matters before adjudicating under honorable NCLAT. Next one is the observations of the IBBA. That is timelines. What are the timelines? Code read with regulation specific timelines. On the last page of the last pages before forms in the regulation, the timelines are table is also there. T plus 1, T plus 3, T plus 14, like that the up to 180 days the table is available in the regulation. Only half page only. Every day we have to look into that one, whether we are in time or out of the time. And the code with the regulation specific timeline for each task of the CAR, as well as the overall timeline. Here we need not wait up to last date. That is the upper limit they have given. It doesn't mean you should not complete before. We can complete the particular task before. Suppose as per the book of records, all claimants are submitted. Then immediately you proceeded to submit the information, segregation of the claims and submit the information to the adjudicating authority and form the COC. We should not take in the up to last minute. So if at all we are delaying that one up to last day, if at all any eventualities are happening, then it is further delayed and it attracts penalties also. So that's why here time management planning is very much required for the IRP or RPs. It is a duty of the IRP or RP to ensure every task of the CA completed in time unless directed otherwise by the competent authority. Okay. Some cases, some delay is inevitable. Get the approval of the appropriate authority and complete the same. This endangers the life of the city. If at all delayed, the value of the asset will deteriorate. The standard asset will turn into non-performing asset. Standard asset means I am not talking about banking point of view. The good asset will turn into non-performing asset. Suppose once the machinery is timely sold, then the value will be more. If at all delayed on account of rust and non-functioning and some other repairs, the value will become down. Stakeholders and frustrates the object of the code. 27 case of the disciplinary case of the disciplinary committee against the insolvency profession, IRP or RP or liquidator. This is a Jogma Laminates Industry Private Limited. This is a CARP case. This is dated 3rd July 2023. The order was released by the disciplinary committee. What are the contraventions or what are the drawbacks or what are the wrongdoings that are done by the IP or IRP or liquidator? Non-cooperation with the IA and in conducting investigation authority. That is important. They are coming from either from IPA or IBBA. Once they visited to your office, you have to give the full support or cooperation. Whatever the information he requires, you have to provide. This is also clearly mentioned in the code of conduct of the IP. The IP did not cooperate with the investigation authority in submission of specific responses to the observation of adjudicating authority and relevant records for investigation, thereby frustrating the entire process. Once I have not provided all the way from Delhi, he is coming to my place and he wants to verify the records and books also. Excessive fees claimed by the RP, adjudicating in its order dated zones. Whatever the fees that is approved by the adjudicating authority at initial stages, thereafter, whatever the COC made adverse comments against the IP for charging the same fees for the COVID-19 period as he is charging during the normal period. In the COVID period, lockdown, shutdown, no movement of the people, and units are also not functioning. And his services are almost zero. He is also in the house. Why he is charging high rate of high professional fees? It is not to be treated like a fixed cost. Whether the volume is increased or decreased, the cost remains constant. Because here the approach is to be changed. Once you have not do anything during that period, that is not correct. Inconsistency in action handing over the custody to ex-management. And IP orally opposed the liquidation application filed by him, also handed over to the custody of a CD to the ex-management. And however, no proof of record, substantial allegation. Whatever he told, there is no proof. So once anybody is blamed him, definitely he will something different to the investigation authority without any proof or evidence. Non-submission of a relationship and cost disclosures. Whenever you are appointing the auditors, forensic auditor or transactional auditor or valuers or any supporting staff, you have to declare these people are not related to me, that a declaration is required. IP filed the disclosure belatedly and accept delay in submission of the relationship cost disclosures. Whenever the cost is incurred, CARP, immediately you have to update the registers, immediately you have to inform to the concerned authorities. Non-submission of CARP form with the board, IP filed to file a CARP 5, 6 and 8 forms on the website of the IIIPI. Fail, not submitted, penalty. In that scenario, definitely they will impose the penalty. What a penalty? Suspension restriction for 1 year. They are kind enough. That's why they have given punishment for 1 year only. Once punishment is given, it is a bad remark. Definitely empanelment, they will cancel the empanelment also. And in the coming days, they may take, they may not take also. It is a discretion of the financial creditors who are preparing the penalty and the empanelment list. Learning lessons. Any communication from the board cannot take lightly. Any communication. If IBBA is sent one email, you have to act immediately. Whatever the information, whether it is a fault or right, you have to communicate. If a fault is there, if you fabricated, then the investigation authority people will come and they will verify the facts. So here, Any communication from the board, IBBI, cannot be taken lightly. And now coming to compliance with orders. That is a 20th observation made by the IBBI. What is a compliance with orders? Adjudicating authority issues a direction from time to time to facilitate a smooth conducting of CARP, generally based on the application by the parties, whether financial criteria or operational criteria or the home buyers or the class of criteria or public at a large. If they complain directly to the adjudicating authority, they will issue suitable orders to the IP because he is a court appointed officer. The proceedings before adjudicating authority, judicial proceedings and the directions of the orders of the court. We have to clarify. We have to immediately respond to that occasion. There is no timelines at the earliest. At the earliest. Any non-compliance with any orders may amount to contempt of court. They will take seriously. It is a contempt of court. Such disregard of the order of the adjudicating may jeopardize the CARP, impact on the interest of the stakeholders, and drain scarce judicial resources. So once this type of incidents are happening, immediately we have to answer. Because the total picture about the CARP process, about the company, about the events, about the sub-process, all are known to you. Only you have to respond by email or you have to send the communication to the NCLT immediately. It won't take much time. If at all some time is there, immediately respond. For that also, the IPs are to be made a daily list. Today, what are the things to be completed? First priority, second, ABC analysis. Then this type of problems will not arise. Sometimes we may forget due to workload or the number of people to be handled by you. On account of that one, sometimes it is we may forget, it is a slippage. To avoid that one, we have to maintain diary. Diary means a daily list. The things to be completed today or tomorrow or before 1 week, after by end of this month. Like that, we have to open different pages and we have to jot down. Once it is completed, we have to strike it off. That planner is very much required to avert this type of things. Another case, the corporate data name is Kioros Maritime Limited, that is CARP, dated 27th June 2023. What are the allegations against IP? That is contraventions. Circulation of incorrect minutes of IP circulated. Why incorrect? Once the minutes are preparing during the meeting, the same is to be typed, or sometimes if typing is not happening, get the signature on the paper and take the photostat or PDF file and send it to the relevant people, concerned people. On the same paper, write that one and get it signed, and the same minutes you send it to the scanned the file and attach it to the email by PDF. But what is the need of incorrect minutes? IP circulated means the first COC meeting mentioned that agenda put in the voting has been approved. On perusal, the progress report has been revealed that members of the COC requested 2 days to vote the agenda fixed COC on confirmation from the head office. Some other people they don't sign because whoever is attending for the COC meeting on behalf of the financial creditor, that is the banks, they may not have the delegation of financial powers. Once they don't have the financial powers, they will tell to the IP that we will get the approval from the appropriate authority. Once approved, then I will sign. That is also correct. Once he is not authorized person, that's why even IBBA also from time to time, they are informing to the bankers also, please depute the power, the persons, officials who are having a required financial powers like that to attend for the COC meeting. And but they did not vote within the same time for voting. Sometimes that's why they are not giving the voting. Thereafter, IP circulated the meeting mentioned in the resolution were approved by the COC. Penalty, suspension of registration for 1 year. If at all that minutes, the voting is not happened and he has given that minutes voted like that. And which is highly irregular. That's why the disciplinary committee imposes the penalty or punishment for registration for 1 year. The learning lessons are IP has not done his duty diligently while conducting CARP process of the CD and transgress his authority in treating the resolution as approved when the COC has not communicated its approval to the resolutions. IP's attitude not appearing before the disciplinary committee in personal hearing not once but twice, not responding phone calls also. Once the disciplinary committee asked you to come to attend the meeting means it is our primary responsibility to attend for the meeting because they are the regulators. It is not a personal agenda. It is official only. That's why we have to attend. 2 times he has not appearing before the disciplinary committee DC, and he is not lifting the phones also, which is highly irregular. Shows non-cooperative attitude which warrant a stern action against him. Once these two are there, that is suffice to give the punishment to that particular insolvency professional. Next, the avoidance of transaction. This is a IBBI observation about the IPs. The court read with the CARP regulation cash duty of RP to file application in respect of avoidance transaction, either preferential or undervalued or extortionate or fraudulent transaction for appropriate direction, with a view to claw back the value lost in this transaction. He required to be form opinion on such a transaction within 75 days of the insolvency commencement date and file an application with the adjudicating authority within 135 days of the insolvency commencement date. This is a regulation clearly spelled out. Not allowed by IP to be directed by COC stakeholders. This may reflect the serious direction of duty and breach of trust in addition to the depriving the stakeholders of the legitimate dues. So, the PUF transactions are to be verified and confirmed to the adjudicating authority as per the stipulated norms. And one more disciplinary case that is awarded by the disciplinary committee of IBBA in the case of Inland Facilities Management Private Limited. It is a liquidation. And this is the 19th June 2023 case. In that case, what are the contraventions? What are the allegations? that are made by the disciplinary committee against the insolvency professional or interim or the liquidator. Non-filing of extension of application, an application for seeking extension of liquidation period was filed by IP after almost 5 months. Once that is to be completed liquidation within 12 months. If at all further time is required, well in time you have to submit the request for extension to the adjudicating authority after the date of expiry of the previous extension availed, which signifies that the process conducted during the period was without authority. Once the adjudicating authority not approved, and if at all the liquidation process is going on, it is not a liquidation process, it is without authority. You are not a liquidator. If at all it is a liquidator, extinction is approved by the adjudicating authority, then only you are treated as a liquidator. Otherwise, you are not treated as a liquidator. And whatever the acts are there, that is not the correct and right. In this case, the IP is handling so many assignments. Even in the code also, they clearly spelled out. You have to give sufficient time to handle the case. You are the CEO. Means if at all 17 assignments are there, 17 companies are you able to manage? Simple task. Handling too many assignment of IP was handling nearly 17 other assignment, including a present assignment. That is a total 18. Being not able to devote adequate time to each of his assignments. Once you are unable to handle, we should not delegate. Here there is no outsourcing of your duty, and you should not delegate your duties to others also. And others, they are not competent, they are not the correct persons also. So in this case, what was happened is his liquidation not applied the paper to the adjudicating authority. Thereby, he is not a liquidator. Whatever the acts are there, whatever the sub process are there, is completed after the liquidation last date. That is null and void. What a penalty? Suspension registration for 1 year. 17 cases. Then all cases are to be transferred to others. Because once a suspension of registration is there, 17 plus 1, 18 cases, that is to be allotted to others. And he has to communicate to the financial creditor or the COC member that the disciplinary committee of IBBA has suspended him for 1 year, which is a great risk to the. Is it possible to complete 70, 18 companies? It is not possible. It is not possible. That's why this type of incidents should not occur. What are the learning lessons in this? IP has to be mindful about its capacity to handle so many assignments. That is a learning lesson. Now, supply of information. Now, we will break for tea, sir, for 10 minutes. After that, remaining cases we will discuss. Is it okay for all, sir?
Yes, sir.
Okay, sir.
Okay, sir.
Mm. Sir. Next, the supply of information. This is the findings of the Insolvency and Bankruptcy Board of India. And what are the findings? The success of CIRP largely hinges on the availability of the information to the relevant stakeholders, particularly the COC and the resolution applicants. The resolution applicants will have to provide the information memorandum. The information memorandum covers all the aspects. And whatever the information is there, we have to provide to the COC for taking effective decision. Section 29 of the code casts duty on the RP to provide access to all the relevant information to prospective resolution applicant. we should not leave any information. Otherwise, particularly the information memorandum is a blueprint, particularly it is a brochure, marketing brochure. It covers all the areas. Whatever the single rupee due to anybody, or whatever the disputes are there, whatever the cases that are pending in the various courts, all are to be mentioned. Then only the prospective resolution applicants, they can, if at all any information is missing later on, if that will cause to the resolution applicant, and again that company may turn into sick. To avoid that one, it is a transparent one about the company, about the creditors, about the debtors, about the market, about the demand and supply, about the particular the technology that is imbibed in the company. What are the litigations? What are the dues? How many directors? When it was started? What is the age of the plant? All particulars. And what is the market share? What is the plus point? The SWOT analysis of the particular company, all are to be provided in the, it is nothing but a marketing brochure, but with the full facts and figures. Particularly the valuation reports are also to be accurately correct, they mentioned in the information. Then only the prospective resolution applicant take a call to take the company or not to take the company. Section 29 of the code casts a duty to provide access all relevant information to RP to provide information memoranda in the electron to each member of the COC. The punishment given by the disciplinary committee. What is that name? Wadhwa Buildcon LLP, that is corporate data 1. Pratibha Krushi Prakriya Limited, that is corporate data 2. This is a case that is an order given by the disciplinary committee on 19th June 2023. And what is the contraventions in this regard? The contraventions are non-cooperation with the investigation authorities in conducting inspection or investigation. IP has not cooperated with the investigation authorities in submission of relevant records and in providing clarification for inspection investigation, thereby frustrating the entire process. What is the problem? You know the nuts and bolts of the CIRP process. And the investigate whatever, because you are handling that case, and the handling of the case is runs into 180 days or 270 or 330. You know the total process of the CIRP or liquidation. And whatever the information that is asked by the investigation authority, what is the problem in providing? If at all any wrong thing is there, then only people are hesitated to provide the information. If at all you are right, what is the problem to face the investigation authority? However, it appeared that the circumstances were complying Enough and a series of tragic events stood in the way of leading delays in submitting the requisite document in time. Had they been asked any document, whether it is correct or wrong, we have to provide. If at all we are delayed, then automatically their thinking process will is different. Why he is delaying? And if at all he is committed mistake, that's why he is delaying the process like that. We should avoid that one. If at all we are perfect, there is no problem to supply the document within the time. Some problem is there, brought to their notice, thereby the penalty will reduce. Inclusion of claim promoters without verification. Promoters claims without verification. You have to verify. If at all the claim is 1 crore, if at all you are admitted at 10 crores, then it is a problem. Has treated landowners and home buyers given voting rights. He had not examined Form B to verify RERA registration of a real estate. And the project which is a declaration, the declaration by the promoter. Land owners are co-promoters of the corporator. On the strength of the voting of the home buyers, Mr. Wadhwa, ex-promoter of that resolution applicant, was approved. However, the same is challenged by the financial creditor with reference to 29A ineligibility. He is not eligible, but this is that ex-partner approved, which is not correct. Reduction of the notice period for 8th COC meeting. IPS convinced they convened the 8th COC meeting by giving a less than 24 hours. Minimum 24 hours is required. And delay in submission of forms CARP4 with the board. CARP4 has been submitted after delay of 252 days, which is not correct. However, he was facing a technical issue. He is telling that he is facing technical. But why is a delay 252 days? Okay, if at all technical issues are there, and you have to send one communication by email to the board. And appointing ex-partner of the prospective resolution applicant to manage the day-to-day affairs. And affairs CD1, a suspended director who is also the prospective resolution applicant was appointed as an industry expert for day-to-day responsibility and directions of the COC, knowing could leverage the information to the CD to his advantage and avail undue competitive advantage. Related parties are not to be taken. He has to give the declaration that this person appointed by me is not related to me and not related to any corporate debtor like that. No verification of claims of the home buyers. When they have purchased, how much advance they have paid, what is the tripartite agreement reached by the finance, the banks and the buyer and the particular real estate company. The claim of 152 home buyers has been admitted without verification, which is a high side. One or two any errors are there that will be obliged. 152 home buyers claims without verification. Not providing supported documents with the COC meetings notice. And IP failed providing a support document with the notices of COC meeting. Once a COC meeting is there, it should be filed properly in a box file. And no determination of avoidance of transaction appointed under section 43, 45, 50 and 60 of the code. That is also required. And however, there is no transaction found after the efforts section, no application filed. Application to be filed with the adjudicating authority. He has to confirm. A mere discussion not held the transaction audit report in COC meeting could not be ground for a violation of a regulation 35A of CA. IPS submission was attainable. Penalty, suspension of registration for 1 year. If this type of number of the irregularities are there, definitely 1 year is a less time, in my personal opinion. Learning lesson: IP cannot be passive spectator and let the CD drift the controlled by ineligible members. Expert, he is known, he is a prospective resolution applicant, corporate data people, all people are there, no independence. Whatever they told, he simply will agree. It is a fundamental duty of the IP to collate the claim and verify that one. 152 claims of the home buyers without verification admitted means that is not correct. Next, this is IBBA findings. Confidentiality undertaken. Whenever the information memorandum is provided and various important documents, confidentiality undertaking to be obtained. And in this case, the code requires RP to provide access to all relevant information of the CD. He is having the right to the resolution applicant, subject to resolution applicant undertaking to comply with the confidentiality requirement. Once the prospective resolution applicant is there, he wants to verify, means before that the IP has to take the confidential agreement. The CARP regulation requires RP to obtain undertaking of the confidentiality from every prospective resolution applicant and every member of the COC before sharing the information memorandum. These are also required RP to obtain undertaking confidential for every member of the COC before sharing the report of the register the values containing the details of fair and liquidation. For that also, even COC members also, they have to give, the RP has to obtain the confidentiality agreement. It is a simple agreement. In one COC, whenever you are handing over the information or declare the information, get the confidential, it is only one page. And get it signed and file it. Thereby, later on, the problems will not arise. If the confidentiality exposes the CD to risks such as insider trading or weaknesses the competitive position in the market, then it creates a lot of problem later on. This may reflect in the intention of the IP to provide privileged access to some persons at the cost of others, compromise valuation maximization. Once it is confidentiality is lost, then it will be a big problem to the company. And this is a 31 case that is declared by order given by the disciplinary committee on one IP or IRP or liquidation. Sukum Power Systems Limited. It is a liquidation account. In the liquidation, liquidator has done some mistakes. The order date is 13th June 2022. What is that one? Contraventions. What are the contraventions against that liquidator? Delay in filing of the progress report. As a liquidator, he has to submit the progress report to the stakeholders. After delay of 126 and the second progress report 93 is delay. Appointment of process advisors. When process advisors appointed during the CARP continue appointed by the liquidator during the liquidation cannot be inferred that the liquidation has not used the power given under the code or regulation to appoint the professional for assisting discharging his duty. Excessive liquidation cost and a liquidator's fees also. Whatever the fees defined during the CARP, last CARP meeting, the COC will define the liquidator's fees. He should not draw more than that. More than that, if at all it is a financial creditor appointed, then or the adjudicating authority appointed, then whatever the amount defined by them, that is that amount only he has to take, not beyond that amount. The total amount charged to process advisors for the service spanning 38 months, 61 lakhs 54, 61.54 lakhs, including GST, whereas a liquidator paid an amount of 5.54 lakhs for the period of liquidation. Liquidator amount is less, but process advisors, he has paid 61.5. What additional duties they have taken, and whether it is a reasonable amount or not, whether the amount paid by them is reasonable or not, everybody will say, you are getting only 5.454, but 38 months aggregate amount, that is 61.54, which is not even high beyond that. Any entity engaged in help the liquidator cannot be expected to entrust the responsibility more than those liquidators. So the justify the higher fee such entities comparison with the liquidator. Whoever is appointed by the liquidator, the fees to be paid by him not more than the person, either IP or IRP or the liquidator. Non-disclosure appointment of professional IP has not maintained the relationship disclosure. Once you are appointed, whoever is there, appointed, the disclosure, he is not related to me or not, like that you have to give the declaration. Patently appointment of profession during the liquidation period, that is vesting. What a penalty. Since IP is already surrendered the AFA, authorization for assignment is application for withdrawal of IP registration is under consideration. It is directed that fresh application for new IP registration or AFA may be submitted by Relhan in future to work profession and IBC may kept abeyance till completion of 2 years from the date of issue of the order. Now is already surrendered AFA, then next once this order after 2 years only, whenever they are approving, that is kept abeyance till completion of this one. That is an order given by the disciplinary committee. Learning lessons, delay in filing progress reports, excessive calculation of liquidation cost, and a non-disclosure of appointment of professionals by the insolvency professional concerning impact on the transparency and the efficiency of the insolvency process. All these are the irregularities that are committed by the liquidator during the liquidation process. Next, IBBA findings. Disclosure of information. What is the disclosure of information? IBBA. The code read with the regulation requires a disclosure of certain information such as commencement of CIRP and the details of list of creditors in public domain. That is communication to be provided. This envisages supply of certain information like information memoranda, evaluation matrix, agenda of meetings of the COC, etc. to entitled person, often taking a confidentiality undertaking. The details of valuation required disclosed every member of the COC in electronic and receiving confidentiality undertaking. Thus, information documents need to be disclosed, supplied entitled person in a specified manner, specified time after meeting of the specified requirements. Information meant to entitled stakeholders were disclosed in public domain. Certain information public were not disclosed in the public domain. That is before and after the specified in the law. So whatever the communication is there, the communication to be passed on to the concerned person, and whatever the relevant confidentiality letter is there, that is to be obtained from them. That is the role of the IP. In case number 32, that is the punishment awarded by the disciplinary committee of IBBA. In one case, the case is Flower Dealcom Private Limited, that is a liquidation. the liquidation date is, the order date is 8th June 2023. The IBBA has given that order. What are the contraventions or irregularities that are committed by the liquidator during the liquidation process? That is one, lack of efforts, realization against the investment made by the CD. CD has investment 10 crores. Once investments made by the, we are not only the asset means not only the building, land and building, plant and machinery like that, or investments are also. In this case, the CD is having 10 crores worth of investment. Whether the investments are to be sell or in the secondary market, they have to get the realization. And here, he has not taken any efforts to realize the against the investment. However, it has mentioned that 13th progress report that no action taken by the liquidator for realization of investment. Why he has given a 13th report? Why not a first report onwards? After persuasion by the different people, that is SCC, Stakeholders Consultative Committee, or the stakeholders, he mentioned in the 13th progress report. And up to 12th report, he never mentioned about the investment, what was happened to the investment of the company, that is 10 crores. But after considering the submission made by IP, it appeared that circumstances has been IP could not do much to get the funds back, as it is evidently money trail was not available. Thus, a lenient view was considered to be taken. Non-opening of liquidation account by the liquidator. As a liquidator, the first step is you have to open the liquidation account. Fail to open the bank account of the CD corporate debtor required under regulation so and so. Excessive delay in conducting the liquidation process. Normal process is 12 months, and if at all it is inevitable, then he has to get the permission and extend the same. The dissolution application filed for a period of 911 days from the liquidation initiation, even when it is clear that there was no realizable assets. Once the liquidation process is completed, the dissolution is also to be completed. But after liquidation, 9-11 days means almost it is more than 2.5 years. This type of irregularities, the disciplinary committee won't at all tolerate. And penalty, IP warned to be more careful, vigilant in complying with the directions issued by the adjudicating authority in her existing as well as a future assignment. And a simple warning was given, and major operational delays may be there, but financial the losses not arised in this case. Learning lesson. Under the IBC, delays in opening the liquidation bank account and conducting liquidation process of the insolvency to frustration and uncertainty. The delay cannot be prolonged. Resolution potentially increase the cost and hindering creditors' recovery. Even the liquidation process also, if at all we are delayed, then the realization amount of the assets will decrease. It is essentially timely action to be taken to ensure fair and efficient resolution. And 25th observation made by IBPI, that is a maintenance of records. This maintenance of records are useful for audit purpose. Later on, any complaints are arise. These records are very useful to address the claim, to resolve the claim, complaints or others. So some of the people, they are not maintained proper records. Whatever the registers you are maintaining, that is till the CARP process, as long as the CARP process, that should be that should be continued thereby. Even after that also, the period of the books that is defined under the IBC code. The maintenance of record is Particularly 39A CIRP requires IRP or RP preserve physical as well as electronic records relating to CIRP of the corporate data. Further, regulation 72G of IP required to maintain records of all assignments undertaken at least 3 years from the completion of such assignment. And in this case, particularly not related to the records. In another case, the disciplinary committee given punishment to the IP, that is in the company Siddharth Intercrofts Private Limited, that is CIRP. Once at Asia Agri Certification Limited, that is the corporate data to voluntary liquidation. In these cases, that is 8/6/2022, they have given some punishment to the either IP or the liquidator. What are the contraventions in this regard? Issue regarding admission of crimes for reconstitution of the COC CD1. IP has received a claim of 8 lakhs 5,000 from one operational creditor, and the COC in the CIRP CD consisted of operational creditor owing the reason that the financial creditors are related parties. Since the claim was received within a period of 90 days from the insolvency commission, thus IP was required to include the name of the list of creditors after due verification. IP did not reconstitute the COC upon the admission of the claim. Once any missings are there, whatever the process completed or whatever the resolutions are completed, that is not to be taken back and that will continue. And the reconstitution of COC is required. If at all any person financial creditor is earlier not admitted, but after thorough verification, now it is admitted, the reconstitution and he has to be included and the voting rights are also to be changed. Failure to filing avoidance application and the avoidance application to be filed by the IP with the adjudicating authority and between the CD and CIRP. Delay in filing the application extension of CIRP. Once the CIRP to be continued further after 180 days, before that only, after getting the approval from the COC, and he has to file with the adjudicating authority for extension. And admitted application extension was not filed within the time of the CIRP forms, also to be filed with a delay. Once after completion of the CIRP days 180, if at all filed, then the adjudicating authority may accept, may not accept, based on the particular case by case. Violation of a board circular dated, the CD, particularly one IP had not relevant disclosures as a mandatory as per his own admission. Whatever the disclosures are there, the IP at the time of the accepting the application or at the time of appointing the valuers or the whoever is there, appointing ineligible auditor. This is a serious irregularity. Once the auditor is not eligible, how he will take as a professional, particularly for the transactional auditor? He is a professional who is served as an auditor for the corporate person. It is clearly mentioned in the regulation also. He is not eligible in contravention of the regulation 11(2) of the voluntary liquidation clause 3, 5, 10 and 14 of the code. And a non-submission of a preliminary report of IP, failed to submit the preliminary report regulation in the voluntary preliminary report is not submitted, penalty, registration is suspended for 1 year. In this case, the registration is suspended for 1 year. What is the learning lessons? Each of these issues are underscores the importance of adhering the procedures obtained under IBC to ensure fair, transparent and efficient resolution process for all stakeholders in. So here, whatever we are discussing the cases, one by one, whatever the irregularities, This is not a great this one. All are clearly defined. There is no technical jargons. There is no technical jargons in this. The rules are clearly defined and it is easy to understand. Being a professional of 15 years or 10 years of professional experience and 15 years of managerial experience, it is very easy to understand. But it is intentionally or on account of various reasons, they are not observing or implementing these regulation, thereby that competent authority, that is a disciplinary committee, awarded the punishment. Cooperation with the inspecting authority, IA, as a IAP or liquidator or IRP or RP, you have to give cooperation to the inspecting authority. The inspecting authority is deputed by the IBBI and the IPA, Insolvency Professional Agency, or Insolvency Bankruptcy Board of India. So whatever the purpose, whatever the information he requires, we have to give correctly so that problem will not arise. If at all wrong is there, okay, we are violating on account of various reasons, or convince them and tell them this is on account of this one only we have did like this. The code enables IBBA and the IPA monitor the conduct and performance of IPs. Inspection is a typical means of monitoring. One is a random inspection is there. Second one is a specific information, specific inspection is there. Random, on account of all the cases, they will pick up certain cases and they will go and verify. Specific means whenever they received any complaint on IP or liquidator or IRP, then they will come and they will investigate the papers that are available with you. The IBBA appoints inspecting authority to conduct the inspection of IP. It is the duty of IP to give all assistance to the investigation authority, produce all records in his custody, control, and furnish all statements and information which IA may require. So in this case, particularly in one case, the disciplinary committee has given the punishment to the IP, that is a Konasima Gas Power Limited, that is a liquidation, dated 7th June 2023. What is that one? Contraventions. Private sale of assets of a CD. One of the assets of the CD sold IP through the mode of a private sale, but none of the conditions for selling of the assets of the CD by means of a private sale prescribed under the regulation have been fulfilled. Once you are selling the private,
हो गया सोए रह गए कि लेट पहुंच जाए कोई बात नहीं
once particularly this private sale is happening, then the process, why the private sale is happening? Why not e-auction or why the private sale? The private sale, what is the reasons are contributed? That is to be narrated and get it documented. Non-listing of a verified carbon units in the asset memoranda of the particular conduct valuation or verified the carbon units not valued registered values. Particularly, the carbon emissions may not released by the company. They are eligible to get the amount from the World Bank, but that is carbon credits. Carbon credits. If at all the companies are following the latest methods of processing, the carbon emissions they may not release. For that, they are getting some amount that is not valued by the valuer. So once it is not valued, you have to ask the valuer before giving the assignment also. whether he is capable of valuing the carbon units or not. They have not even listed in the asset memoranda. This is also an asset that is available. Then they will get the amount back from the World Bank under the carbon credits and asset member and value associated with the provided regulation 34 of the liquidation regulation. That is not it is a intangible asset, but the value is there. But value is there. Already they have contributed the low emissions, thereby they are getting some carbon units credit. This is encashable subject to certain guidelines. So how much is it value? The values are also to be valued properly. In this case, that is not mentioned. And once the information memoranda issued to the particular prospective resolution applying, if it later on he encashed, he will be benefited. He will be benefited. Penalties. Impose a penalty of 2 lakhs to be deposited 45 days issuance of the order. Direct IP to work probationary for 4 months with other experience. Like this is gives a lot of discomfort to the IP. You have to work with other IP. You have to learn. So if that DC is given, disciplinary committee if given this type of the punishments or award, then it is a lot of inconvenience. Some of the people they may pay the penalty and leave the profession. They don't want to work with another IP. Till completion of the provision, the authorization for assignment of IP will remain suspended. And animation will not be take a fresh assignment or service under the code in capacity of IP. Learning lessons. Prior permission of adjudicating authority to be obtained for private sale, unambiguous and needed to be followed. That is required. So whatever the private, this one is there. You have to get the permission from the appropriate authority. Next case is 35. That is a punishment given by the disciplinary committee, DC. VMX impacts private limited. It is a CIRP. The punishment given order dated 26th May 2023. What are the allegations on the IP or contraventions on the IP? Admission of a claim is barred by limitation. Simply admitting the claim based on the proof is also not sufficient. As per the Limitation Act, Section 18 or 19, whether it fulfills the documents are not time barred or not. If time barred, the claim is not to be admitted. The claim is not to be admitted. It is noted in the Section 7 of the application CD filed, Ekta Kare claimant was rejected by Honorable NCLT wide order on the ground that the debt was time barred. Once Honorable NCLT is rejected the claim, why the IP is admitted the claim in the claimants list? It is a time bar. The order is also given by the NCLT. However, post-admission CD, CIRP, her claim is admitted by IP in disregard the adjudicating authority order. You are violating that because after thorough verification only, the Honorable the adjudicating authority given direction, this is not to be admitted, it is a time bar. In that case, we should not include in the claimant's list. But in this case, what has happened? He admitted the claim. Inconsistency in the information memoranda and valuation report. Whatever the information memoranda is there, valuation report, it is particularly in the valuation report only mention about the floor area ratio, but not non-floor area ratio. Particularly with regard to the buildings and all these things, the floor area ratio to be mentioned, and now they mention only floor area, ratio, but a non-floor area ratio also to be mentioned, because thereby the value of the premises will increase. Since it is a commercial property, both the floor area as well as non-floor area may have been potential commercial use, and since the formed the part of the valuation report, the entire area of a mall, floor area as well as a non-floor, should have been mentioned in the information. But here also is not mentioned. Okay, whether it is because of the technicalities, some of the IPS may not have the knowledge. Okay, this type of small things they may oblige also. Issue of aversion builders private on the date of verification of the claim, existing arbitration award was knowledge of IP. Still, IP is admitted higher claim. Once it is in arbitration, the arbitration is going on, and whatever the claim is there, beyond that higher claim is admitted. Inaction of obtaining records of the CD, where the considerable amount of delay in obtaining the records of the CD. Once day one, once you are occupied the seat, you are having the right to access all the records of the CD. Why the delay was happened? Penalties, suspension registration for 2 years. In this case, they have given 2 years. What is the learning lessons? In conclusion, highlights the several concerning with insolvency resolution of the corporate data. So many irregularities are committed. That's why floor area, non-floor area is only one small area, small issue, but remaining issues are the serious nature. These discrepancies are oversight the raise of questions about the fairness and transparency of the resolution process, but also underscore the need of a stricter adherence, guidelines, directives in the insolvency process. Addressing these issues are essential to ensure the integrity of the insolvency proceeding and upholding the interest of all the stakeholders involved. Next, 36, the case, particularly the disciplinary committee awarded punishment to the IP, the 36 case. It is a Prince MFG Industries Private Limited. This is related to CIRP, and the date is 23rd May 2023. Contraventions. What are the allegations against the IP by the particularly disciplinary committee, DC? Misrepresentation regarding the Minister of COC. IPR is represented himself as a RP, duly appointed by SPA, despite a COC having vote against him. Once they have given against this person, he is continuing as an IP, the RP. They voted against the agenda for appointment IRP as RP. The percent of E voting in the first COC meeting. He failed to record the same in the minutes instead of misrepresenting himself as a RP on various occasions. Once they have not given authorization that you are a IRP, we don't require your services as an RP. From the first meeting also, he is while circulating the minutes, he is as if he is a resolution professional, which is highly irregular. Entering MOU with the COC without COC approval, IP has already entered MOU with a third party, that too from the retrospective data, while COC considering getting a MOU vetted. And thus signing MOU for the contract manufacturing activity required transparency not maintained by the IP. These are the irregularities. What penalties? Suspended registration for 6 months. Suspended registration for 6 months. What is the learning points? In the learning points, IP is appointed for IRP for CD, has no performing function. RP till another RP is appointed by the COC. This is a temporary arrangement which deemed friction for IRP and no way means IRP is confirmed or appointed as a RP by the CD. Okay, as per regulation also, till appointment of the RP, the IRP will continue as an RP. It doesn't mean that COC is approved him as an RP like that. Next, 37 case of the disciplinary committee and what a punishment awarded to the IP. Rama, the Developers Private Limited. This order is given on 23rd May 2023. What is that order? Contraventions, allegations against the IP in CARP process. IP in its capacity, IRP and RP has failed to represent interest of the CD ongoing cases before debt recovery tribunal. Mumbai. The application was filed by one financial creditor having majority votation recover money due from the CD. IP did not seek pursue the matter before the DRT. Whatever the cases are there, we have to attend, we have to communicate properly to the DRT also and fail to protect the interest of the CDs. IP has failed to maintain independence to act objectively by keeping the CD unrepresented before DRT. So thereby, penalty is advised to diligently perform the functions provided under the code. Here, the major loss is not there to the company or the corporate debtor. That's why they have given warning to the RP, IP. Learning lessons. Code provides RP to represent, act on behalf of the CD with the third parties. Exercise right the benefit of the CID in judicial or quasi-judicial or arbitration proceedings. Hence, it is the duty of the RP to represent the CD before the honorable court or tribunal and apprise the factual position of the CD. You have to attend to the debt recovery tribunal. You have to tell that I am particularly the company is undergoing the CARP process and you are appointed as a IRP or RP, and then their judgment will be in a different manner. Because, okay, IBC prevail over the other acts, even DRT or Surface Act, whatever it is there. But we have to communicate to them. And simply, if at all you are not attended the court cases or any arbitration cases, they may give in the different judgments. The case 38 of the disciplinary committee with regard to the Base Corporation Limited. It is under liquidation. The date of the disciplinary committee order is 19th May 2023. What is that order? Contraventions against the liquidator. Non-consultation with the stakeholders consultative committee. Once the stakeholders consultative committee is appointed, rationale is there. You have to inform. You have to take his advice. Sometimes you are taking his own decision based on, even though the information may not be correct. You have to take your own decision, but you have to listen, consultate. Various details such as the pre-bid qualification, reserve price were not discussed with the stakeholders committee, which will lead to withdrawal of first e-auction after objection by the stakeholders consultative committee. Failure to represent CD before adjudicating. Non-appearance of IP has been recorded in the order of adjudicating. Once the case is in NCLT, whatever hearings are there, all hearings you have to attend. And if at all not attended, the adjudicating authority view is different. Adjoining location vital importance as it disposes rendering plant and land landlocked status, thereby serious impact on the price of the assets adversely. However, an appeal filed by the IP, ideally during the pendency of the appeal, honored by NCLT property in the question should not have been put in auction as per the own admission of the IP. Value of the property has been diminished significantly. But ignoring the importance of vital fact, IP put the property in question to auction. So, if this type of incidences are there, you have to brought to the notice of the adjudicating authority and their decision is final. Delay in filing progress report. Being a liquidator, this is not a way. Okay, during that month, if at all nothing was happened, whatever the last month report is there, that is to be copied and send it to the no additions, no deletions. And the first, second, third progress report filed after 240 days and 150 days, 180 days respectively, which is not correct. However, fourth report has been filed even till the date of the order. Irregularity constitution of the stakeholders committee with the representation of the stakeholders. Stakeholders consultative committee is also properly done or not, that is to be ensured. List of claimants admitted by the IP comprise secured financial creditor, employs government authority and operational creditor. However, as per the notice of fourth and fifth stakeholders concerned, names of only financial creditor, EPFO has been mentioned. What about the others? The government authorities, employees, there is no document pertaining to inform the same employees and other operational creditor to nominate the representatives of the participation in the stakeholders committee. These are the irregularities that are committed by the particularly the liquidator, burdening stress on the CD with unreasonable expenses. So even though we are in liquidation, we have to get the maximum amount. The hair cutting or haircut should be reduced and the maximum amount to be distributed through waterfall mechanism to the stakeholders and unreasonable expenses are to be curtailed and appointed as a registered valuer who is registered for securities category only for calculation of enterprises on the basis of previous done during the CAR. However, the code regulation do not require liquidator to seek opinion or appoint another valuer to review the subject matter of the previous valuation conducted during the CARP. So, he is not having the authority. Whatever the reports they have given, that is final. And he is not an investigating authority in the valuation reports. It is a futile appointment only serving increase the liquidation cost without advice of the stakeholders consultative committee. Penalty, suspended registration for 2 years. Because if at all exorbitant, intentionally he is appointing some more values where there is no need, it is an additional cost. That's why he has suspended for 2 years. Learning lessons. In conclusion, the case exposes to critical shortcomings in the insolvency resolution, raising significant concern about transparency, compliance, and stakeholders representation. It highlights the systemic issues, undermine the integrity of the resolution proceedings. Addressing the deficiency is also essential. Principles of fairness, efficiency, all these things are required. Failure to require these issues jeopardize the interest of all the stakeholders. So here also, lot of irregularities are committed by the liquidator. That's why 2 years of suspension is correct. Next, 39 case. That is Disciplinary Committee 39. It is James Hotels Limited. It is a liquidation. That is an order given by the Disciplinary Committee on 18th May 2023. The contraventions or allegations against the particular liquidator is IP has prescribed non-refundable process participation in addition to earnest money deposit in the e-auction. earnest money deposit is there, non-refundable process of participation fees. He is devised. However, submission made by IP amount collected from non-refundable participation was deposited by the bidders in the liquidation account, and no unjust enrichment has been caused to him seemed justified. So penalties are imposed, show cause notice, disposed without any direction. Learning lessons. In conclusion, imposition of non-refundable process participation during e-auction along the particular earnest money deposit. The insolvency professional justified the fees of the show cause notice disposed of by the disciplinary committee. Last case, that is the 40th case of the disciplinary committee. Hindustan Board Oliver Limited liquidation. That is 16th May 2022. What are the contraventions or allegations against the liquidator? IP charged excess fees. In most of the cases, particularly in disciplinary cases, these IP charges are also more. And IPE, sometimes IPE is drawing much more than. Sometimes the services provided by the valuers or specialist, it is much more than the IP fees, which is an objectionable one. Penalties. Directions about conduct inspection with regard to fee charged by Amit Gupta in all liquidation process being handled, liquidator submit the report within 2 minutes. So once this case is there, they are verifying the other cases also. How much charged in other cases, whether it is an exorbitant or whether as per the particularly financial criteria or COC agreed amount or not, all these things. Sometimes they will verify the other cases also. In this case, the complaint was received and other cases also they are having a right to verify. Learning lessons. In summary, charging excess fees to the liquidator and IBC can result in various legal consequences. The present case highlights the importance of adhering the prescribed fee structure and acting with integrity and transparency throughout the insolvency process. So this is a learning lessons, and the 41 is also there. That is a disciplinary committee. RLS allows the private limited liquidation. That is order dated 16th May 2022. This is also liquidation case. And the contraventions. Conducting of e-auction IP conduct a fresh e-auction, rescheduled auction without publishing notice. Whenever second auction or third auction is there, every time you have to give the intimation to the public that we are going to give we are doing the auction, and without publishing the notice for the same, thereby failing in the responsibility and explore many potential bidders and maximizing the value. Some hidden agenda may be there. That's why he has not given the advertisement. He declared same bidders successfully and offered 40 lakhs, 45 below the previous bid. And in the liquidation also, number of cases, particularly if you compare the CIRP and the liquidation, in the liquidation, number of the disciplinary proceedings or actions initiated by the liquidator are more. Penalties, suspension, registration for 2 years. Learning lessons. In conclusion, the case highlights a significant lapses on the conduct of e-auction by the IP. In these cases serve the reminder importance of adherence of the procedural guidelines. Ethical conduct of the insolvency safeguard the interest of all involved parties, maintaining the trust and insolvency resolution process. So that's why we should be more careful in the liquidation process. So number of complaints are originating. Whenever they are doing the random audit in liquidation are more, and the violations are also more in this. Name of the case is 42. The Watson Healthcare Private Limited, that is CD. Kioros Maritime Limited, that is CD2, that is 15th May 2023. Contraventions in the CD1, it has been noted there was a delay in verification of claims. Once the claims are verified instantly, and it is gives a scope to form the committee of creditors. However, submission of IP observed verifying the claims based on the material data available with IP. Okay, sometimes it may be delayed, but delay also to be recorded. Okay, some evidence are not mentioned, and some papers they have not submitted, and you have called for that, and we have given sufficient time. Due to the consolidation by the said group was confusion. In the CD, breach of a moratorium notice at CIRP has been stayed. Honorable High Court on so-and-so date, so-and-so reviewed on so-and-so. As per the transaction, bank account, CD has receipts of 21.32 crores towards insurance claim. Actually, here, the corporate debtor received 21.32 claims from the insurance company on account of a fire or damage of the assets. And claim payment and the patents, patients, and the payments to the tune of 11 crores in the account, Dr. A.M. Arun, one of the promoter and his related parties. Out of this amount, they have paid 11.96 crores. The findings of the transaction audit evidences gross negligence and carelessness on the part of the IP. During CARP process, whatever the funds they have received, and accordingly they have to distribute it as per the waterfall mechanism in the liquidation process. And the appointment of expert professional advisor, and did not share the full profile of the professional engaged. Once you have taken the services of professional, for what purpose, what is his qualification, whether he is the right person to occupy that professional seat. Mr. Kulbhushan has a past association with one of the resolution applicants. He is also almost a related party. Penalty, suspension period is one year to the liquidator. Learning lesson, particularly these lapses are there. These lapses are not small lapses. It reduces the funds of the stakeholders in the liquidation process. Now coming to conclude. So far I have discussed about 42 cases. Okay. Anyhow, I am supplying this PPT also to you. In almost all cases, the system violation on small issues, minutes are not circulated, wrong minutes are circulated, high professional fees is charged instead of authorized amount, and related parties are taken into account, and claims are delayed is there, or they have not taken into account of the declaration of the IP, particularly whenever he is appointing. So all are simple one, but on account of this one, the problems arise to the corporate debtor is more. That's why, based on the seriousness of the issue, it is easy because all these points, everybody knows about all these points. Minutes are to be circulated, or if at all you are giving a notice below 24 hours, it should not be. And second one, you should not appoint the related parties. And the information memoranda should cover all these things. Even in the carbon units also you have to mention. And whatever the workers' claims are there, that is to be included. All these things everybody knows it. But a violation of these rules means some hidden agenda may be there. And whenever you are doing something, and the proofs are to be built up in a sequence manner in box file. Whenever the investigation authority is going to investigate your cases, the date-wise sequence papers are to be arranged. And then there will not be any problem. So to conclude this one, recently in the valedictory address by Dr. Rajiv Kumar, Vice Chairman Niti Ayog, it was urged to IBBA and other stakeholders to have a systematic plan to improve the India's ease of doing business. Once the IBC cases are quickly disposed, the ease of doing business of the country will increase it further. Earlier, it is 145, after that 132, now it is 63. The 63 will increase further also. The quick disposal is required. The efficiency of IBC cases are required. Prompt resolution is required. No hidden agenda. The IPs are to be followed, the rules, regulations, and code and judicial pronouncement. And a delay should not happen. And whatever the information memorandum they are going to provide, that is a transparent, no related party. The efficiency is very much required. Once the efficiency is there, then automatically the message will percolate to other countries, investors also. If at all I invested in that particular country, and if at all the company is facing any problem, I will recover my amount through IBC at the earliest. The strong code is there, then the professionals are also, quality is there. If all these disciplinary cases are increased, then it is very difficult to get the higher rank in the ease of doing business. That is the message of the Vice Chairman Niti Ayog. Needless to report, IBC has enforced with a similar objective. The preamble also clearly told, maximize the stakeholders, time value of the money, quick disposal, and you have to take care of the corporate data. And you are the CEO. The suspended director should not enter into your deliberations. And if at all you are giving scope to the CDs to operate the company's account instead of by you, if they are operating, you are not giving importance to the regulations or code. The insolvency matters extremely high stake for not only the parties, that is corporate data and financial and operational, but also deep impact on the economy of the nation. This is to be continued as a going concern. If at all is delayed and nobody is ready to take that particular company, then the company natural death will happen. Once the company death has happened, the GDP will decrease. The earlier employees turn into unemployed. And if at all it is an export oriented, the forex results will also come down. All these things, the side effects are there. So that's why, as far as possible, not a recovery plan. IBC is not a recovery plan through liquidation. It is a resolution plan. That company to be handed over to the another promoter who is capable of handling that one, and he has to run the company in an efficient manner. Thereby, he is safeguard the GDP growth. He will safeguard the employment opportunity. He will safeguard the, if at all it is a export oriented foreign exchange research, etc., etc. Thereby, the ease of doing business rank will increase further. In the light of disciplinary committee, has rightly laid down the responsibility of an IP. Once the disciplinary committee is there, their role is whether the professionals are doing their duties, checks and balances are there. If at all they are doing wrong things, the total system will collapse. There is no value for the particular profession. So somebody has to control, somebody has to verify, somebody has to correct whatever the errors are there. That is the role of the disciplinary committee. RP requiring a highest level of standing, calibre, integrity, inspire confidence, trust of the society and the state. If at all IPs are doing effectively and efficiently, the profession liked by the people, the stakeholders, the society has a whole. And the society also, they are auditing about the company, whether the company is going into the hands of the safest people or not. If at all that is not happening, the public in the society also don't believe about the IBC system. That is also very important. In such a scenario, where India looking towards the creative of the economy and more investment for FDIs and ECBs, always our country should attract more foreign direct investment and external commercial borrowings. This will happen once the recovery system through IBC should be a good one. If at all it is not good, nobody will invest, no foreign direct investment, no external commercial borrowings. Tomorrow, the IBBI is going to introduce cross-border insolvency. For the cross-border insolvency also, this is the profession code to be followed by the professions in a better manner. In order to expand the economy, make the GDP more robust, their urgent requirement, strict checks are required. The every step of the IB to be monitored, to be controlled by the IPA or IBBA for the smooth running of the insolvency resolution process. And in turn, the sole profession who runs the show. Once the IP is there, definitely the company will run in a better manner when compared to the earlier one. So this is in brief about today's and yesterday's discussion, sir. And my only suggestion, follow the rules, follow the regulation, and follow the code, and follow the whatever the judicial pronouncement. It gives good results in the long run, and your image in the market will increase. The financial creditor or the operational creditor, they will like, and the public as a whole, they will like the profession. In the world, the IP profession is everybody will like it. So this is in brief, sir. Thank you very much for your patience listening yesterday and today also, sir. Thank you,
Thank
sir.
you, sir.
Thank you, sir.
Thank you.
Thanks a lot, sir. Thanks a lot. Thank you very much. We enjoyed your session.
Thank you, sir. Thank you, sir.
Thank you, sir. Thank you for sharing your experience
Okay,
and
sir.
learning and making the session interactive and insightful.
Okay, sir. Thank you, sir.
Thank you, sir. Thank you. Thank you.
Okay, sir.
Good to leave, sir.
Now I am closing, sir.
Thank you.